Hi, my name is Erich Straub. I'm an immigration attorney with Straub Immigration, and in this video today we're going to talk about marriage-based applications for lawful permanent residence. Applications by a U.S. citizen or a permanent resident for someone they've married who's a foreign national. Now, there is an important distinction between a U.S. citizen filing for a spouse and a lawful permanent resident filing for a spouse. And we're not going to get into that in great detail today because this is an introductory video. But if you're a lawful permanent resident filing for your spouse, there are only a certain number of visas that are available each year. Whereas if you are a U.S. citizen applying for your spouse, it's unlimited. So when you're filing for your spouse, the process starts in the same way with a form called a petition for alien relative, or what we call in the immigration field an I-130. And because it starts in the same way, the process can seem deceptively simple, but unfortunately, immigration law is very complicated. And even though you use the same form to start the process, there are three distinct ways to apply depending upon your spouse's circumstances. If you choose the wrong way, you can cause significant problems in the application process. So which one of the three ways applies to you? Well, that really depends upon how your spouse crossed the border. And in immigration law, we have a concept known as lawful admission. Lawful admission is defined as being inspected and authorized by an immigration official. So how do you know whether your spouse was lawfully admitted? Well, the easiest way is to simply go look at their passport, and there's probably going to be a stamp in it on the day that they entered the United States. You could also look for what's called an I-94 card. It's a small white card that normally has the stamp on it. So we've talked about the concept of lawful admission. Now let's go to how that affects the three different ways that you would apply for your spouse. And those three ways are, first, adjustment of status; second, adjustment of status under 245I, which is a provision in the Immigration and Nationality Act; and then lastly, consular processing. So if your spouse has been lawfully admitted to the United States, then you're eligible to file for adjustment of status. And the main benefits of adjustment of status are that your spouse gets to stay in the United States while the process is going forward. They can get a work authorization, and they can travel abroad. So if your spouse does not have a lawful admission, the spouse still may be eligible for adjustment of status, but they have to fit under the provision known as 245I. And in order to fit under that provision, they have to have had an application, either a family-based visa application or a labor certification, filed for them on or before April 30th of 2001. Now, if your spouse does not have a lawful admission and they don't fit under 245I, then you're going to have no option but to go with consular processing. And the big disadvantage to consular processing for most couples is that it's going to require your spouse to return to their home country and process through the consulate there. And it's not going to provide them with the ability to get a work authorization while they're still in the United States. So for many couples where the spouse has not been lawfully admitted to the United States and is in the United States undocumented, consular processing provides the only option for that spouse to get permanent residence. But there's an additional step that is very important. It normally requires a waiver for them to be approved for permanent residence. So this has been an introductory video about marriage-based visas, and we really can only give you an overview of some very complicated processes in this video. I would encourage you to go to our website and look at some of the other videos that we have that go into greater depth. This has been an informational video, and in order for you to fully assess and make an informed decision about whether to go forward or not, you really need to seek the advice of a competent immigration attorney. At Straub Immigration, we have a reputation for achieving results in even the most difficult of cases. And whether your case turns out to be fairly straightforward or one of those difficult ones, I would welcome the opportunity to represent you.